series by MP Siddhesh. This is part 1 of the revision lecture covering the topic of legislative relations. I highly recommend watching all the parts for a complete understanding of the topic. In this video, we shall cover the following. Number 1. What is a federal system? Number 2. What is legislative competence or legislative jurisdiction? Number 3. We shall discuss the doctrine of territorial nexus in detail. Number 4. Introduction to the concept of subject matter jurisdiction. And finally, in this video, we shall cover the basics of the union list, the state list, and the concurrent list. The remaining subtopics like the doctrine of repugnancy, the doctrine of eclipse, the doctrine of severability, the residuary powers, and the parliament legislation in state field shall be dealt with in the next few videos in this series on legislative relations. Let us become familiar with the concept of federalism. Very simply, a federation is a union of states. The federal system of governance has been endorsed by the Constitution of India itself under Article 1 by expressly stating that India, that is Bharat, shall be a union of states. In contrast to the unitary form of government in a federal system, there exist two levels of the government, that is, the union government and the state government. Please remember that one of the unique features of the Indian federal system is the existence of a third level of government, that is, the local governments or local government bodies like gram panchayats, municipal councils, and similar such local government bodies. Let us come to terms with the concept of legislative competence. Very simply, legislative competence means the power or the capacity of making laws. The general rule is that a legislature cannot legislate beyond the powers conferred upon it or granted to it by law. A legislature can only make laws within the jurisdiction conferred upon it or granted to it by law. It cannot travel beyond that. One must never forget that limitations imposed by law on legislative power is one of the essential features of any system governed by the rule of law. For example, in a monarchy, the king has unlimited and arbitrary lawmaking power. In contrast, in a country like India, there exist limits on the lawmaking power of both the center and state legislatures. So, we have also explored the relationship between rule of law and center state legislative relations in this slide. Legislative competence or jurisdiction of a legislature can be broadly divided into two very obvious categories. Number one, the territorial jurisdiction, which pertains to the territorial limit of a particular legislature. Number two, subject matter jurisdiction, which pertains to the subjects or the topics or the heads based on which a legislature may make laws. In the next few slides, we shall become familiar with the doctrine of territorial nexus. This doctrine or this concept is related to the concept of territorial jurisdiction which was discussed in the previous slide. Nexus simply means a connection or a link. Therefore, territorial nexus means connection with a specific or particular territory. The general rule, which is also a rule of common sense, says that a state may only make laws which are operative or effective within its own territorial limits. This means that a state cannot make laws which have an extraterritorial operation or effect. For example, a law passed by the Maharashtra legislature which affects persons located in Manipur. It will have extraterritorial operation and may be challenged and struck down as being ultra vires of the Maharashtra state legislature. Therefore, the doctrine of territorial nexus is an exception to the general rule mentioned in the previous slide. When a law which is passed by a state legislature is challenged on the ground that it has an extraterritorial effect, the question faced by the courts is whether or not there exists a sufficient territorial nexus to justify the extraterritorial operation of a particular law. There is no objective test for determining the answer to this question. Whether or not a law has sufficient territorial nexus must be determined or decided on a case to case basis. Even if there is no objective test to determine the question of territorial nexus, there is some guidance available from the Honorable Supreme Court pertaining to the question of territorial nexus. Two conditions must be satisfied. Number one, the connection must be real and not illusory. And number two, the liability sought to be imposed must be pertinent or related to that connection. This is not an easy test to understand in abstract. Therefore, let us look at some of the important cases in the next few slides for a better understanding of this concept. Let us briefly skim through the case of the State of Bombay and RMDC. In this case, there was a real connection between the state and the respondent who was located outside the state because, number one, there were a large number of consumers in Bombay state, and number two, there were collection centers set up by the respondent in Bombay state. Moreover, the liability, that is, the tax on gambling in this case, was pertinent to that connection. Please take a moment to read the brief note given here in this slide for better understanding of this case. Now, let us look at another example for further clarity. In this case, it was held that a trust regulation law passed by the Bihar legislature could have extraterritorial operation if the trust was located in Bihar, that is, if the trustees were present in and functioned in Bihar. At this point, I recommend that you should read the full judgments mentioned in this slide and the previous slide. It will help you immensely in understanding the thinking of the Supreme Court while determining such questions. As always, I have provided a citation for your quick reference. In the next few slides, we shall explore the basics of subject matter jurisdiction of a legislature. First and foremost, it must be remembered that the distribution or the division or the compartmentalization of legislative powers is an essential feature of any federal system that is existent on this planet. There can be no fixed formula for dividing the legislative powers between the center and the states. The general rule in this case is that number one, the center can legislate on topics or subjects of national importance like national defense, currency and the bank rates, and foreign policy. On the other hand, topics or subjects which are of local or regional importance are dealt with by the concerned state legislature. Now, let us become familiar with Article 246 of the Indian Constitution and Schedule number 7 annexed to the Indian Constitution. Schedule 7 contains three lists. They are the Union list, the state list, and the concurrent list. The center has exclusive competence to legislate on the matters enumerated in the Union list. The states have exclusive competence to legislate on the matters enumerated in the state list, and finally, both, that is, the center and the state, have competence to legislate on the matters enumerated in the concurrent list. This system is full of overlaps and conflicts, even if it sounds quite simple on paper. This is because the three lists mentioned in Schedule 7 are not watertight or exclusive, and there is a great degree of interplay between the three of them. In the upcoming video in this series on the center-state relations, we shall explore the doctrine of repugnancy and residuary powers of the parliament, that is, the central legislature. The interplay and the overlap between three lists mentioned previously shall be fully explored in the upcoming lecture. Thank you for watching. I highly recommend watching all the parts in this series to gain a complete understanding of the topic of legislative relations, and so that you can answer any question which shows up in the exam with great confidence. Once again, thank you for watching.